So the next topic is Crown Court appeals. So what we're looking at now is we are looking at cases that have had their first hearing in the Crown Court. So that is your indictable cases or serious either way cases. So you've been found guilty or you've pled guilty in this court, and there are two routes for appeal here. So you can appeal as a defence or you could appeal as a prosecution. You need to be able to go through both for an 18-mark exam question, and then you need to know the defence appeals for a 12-mark application question. So there are two types of appeals that can come under the Crown Court powers, and these are both for the defence. So both of these are for the defence. So you can see up here, these are defence appeals. Now, the first type is conviction appeal. Now, conviction appeal is where you've pled not guilty at your trial. You've then been found guilty by a jury, and you've received your sentence. Now, if the defendant pleads not guilty at trial, they can appeal against both conviction and sentence. If you plead guilty, you can just start an appeal against your sentence. Now, the rule is either of these cases, you have got 28 days to file this appeal. So you've got 28 days to start your appeal off in Crown Court. Now, the rules of the Criminal Appeal Act 1995 basically says that you can appeal either one of them, so the conviction or sentence, to the Court of Appeal Criminal Division. Now, you must get leave to appeal from the Court of Appeal. So this is a certificate that's from a judge that says that this case is fit for an appeal. So it needs to have a really good point of law in there. Now, there is only one ground for appeal that is from Crown Court cases, and that is that the conviction is unsafe. So that basically means that there is something in that conviction that means that it's not a full conviction, and there's some element that brings doubt into the mind as whether it is safe. So, for instance, if any new evidence comes to light, so if a new piece of DNA evidence gets found or a new witness comes to light, that would class the conviction as being unsafe. And then the Court of Appeal, what would happen is if you get leave to appeal, the Court of Appeal would consider every piece of evidence, everything that was admissible at the trial and everything that could have been admissible but perhaps wasn't used at the time, and they'll use it to form their appeal. Now, they have got a couple of powers in this line. So if you've done a conviction appeal, they could uphold the decision of the Crown Court. That means that they agree with it and you are keeping that conviction. They could quash your conviction. By quash, it sort of means like squash. So you are getting rid of that conviction and you are found not guilty, so you are acquitted. Or they could lower the charge, so they could vary to a lesser sentence. So if you're found guilty, if you're found guilty and you're appealing a Section 18 grievous bodily harm charge, they could downgrade it to a Section 20 grievous bodily harm. Or if you've been found guilty of theft, they could downgrade it to a taken without consent instead. Now, in terms of sentence, they can confirm your sentence, so they can agree with your Crown Court sentence. They could reduce the sentence, so they could actually give you a lesser sentence, or one thing to note on there is they could vary that sentence. Now, if you have got new evidence that's come to light, they could also ask for your case to be completely retried in front of a new jury. Now, there are not many done in terms of this. Now, a very interesting case that has just happened is the Ched Evans case. Now, Ched Evans was found guilty at Crown Court and sentenced and spent 2 years in prison. I think his sentence was 5 years long. He then had additional evidence which was about the claimant's past sexual history of the rape charge that he felt it was necessary to bring in. So he went to the Court of Appeal with the evidence and they looked into this and decided it should have been available at trial. So what they did is they ordered a retrial, and he's recently had his retrial and been found not guilty. So you can see the importance of this appeal option and the idea that if any new evidence comes to light, then they can order a retrial around that and get another jury to look at the case. Remember, it is a different jury that will look at that case. Now, another important aspect is the Criminal Case Review Commission. Now, the Criminal Case Review Commission can refer Court of Appeal cases if there's been a miscarriage of justice. Now, these work independent from families, defendants, they can have their investigations brought to them by either of those. So the defendant can ask the Criminal Case Review Commission to look into a case. So can their family cases, but sometimes the Court of Appeal can refer them as well. So they can decide a case that they think needs appealing and refer it to the Criminal Case Review Commission for investigation. Now, what they can do then, once they've investigated, if they think that it is suitable for an appeal, they will refer the case to the Court of Appeal. If they believe there's been a miscarriage of justice, so it's purely based on miscarriages of justice, so that is where an innocent person has been found guilty. And it has to be used when all other appeal routes have been exhausted. So they've tried going to the current Court of Appeal before and it's not really worked, so they can go through the Criminal Case Review Commission instead. Next thing that we need to know are the prosecution appeal. So the prosecution does have a route of appeal from the Crown Court, and they can be under a number of different ways. So a prosecution cannot appeal against verdict or a sentence that was passed against Crown Court, and they have got limited appeal rights. So the first one that they can do is they can appeal against an acquittal that's a result of a judge's ruling. Now, this comes from the Criminal Justice Act 2003, and this is if they believe that the trial judge gave a ruling upon a point of law which stopped the case. So that means that the trial judge gave a point of law out which effectively ended the case and meant the defendant was acquitted. So it's sort of like they've made a bit of a misdirection there. Next one, they can appeal from acquittals from the jury. So that is if there has been jury nobbling. Now, jury nobbling is where a jury member is bribed to give a certain verdict. If you think your jury's been nobbled, then you can have an appeal against that. Or if there's new evidence that was not available at the first criminal trial, this can be put to jury. So they can actually look at this and they can set an aside acquittal based on this new evidence and then ask for a retrial. Now, the Criminal Justice Act 2003, this abolished the rules on double jeopardy. Now, double jeopardy is where you can't be tried for the same crime on the same set of facts more than once. So that basically means, for instance, if we look back to Ched Evans, we couldn't just have a retrial of the Ched Evans case. There had to be a new piece of evidence that made the facts different. And if there is, obviously, it then can go for a retrial. So you would find there's quite a lot of ones where like new DNA evidence has come to light. Then we obviously can try again on those facts, even if there's been an acquittal beforehand. They can appeal on a point of law. That's from Section 36 of the Criminal Justice Act. The Attorney General can refer a point of law to the Court of Appeal if the prosecution was concerned about an acquittal. This won't really result in an acquittal, but it will settle the point of law, so they'll actually identify the point of law and then take it from there. And then the final one, they can appeal against sentence under Section 36 of the Criminal Justice Act 1988, but they have to ask the Attorney General to seek leave to appeal. And they're basically saying there's been an unduly lenient sentence from the Court of Appeal and it needs to be resentenced. Now, this is only available for indictable and triable either way offences that have come and been tried from the Crown Court. Now, with both the prosecution and defence, they can have a final appeal route. So after the Court of Appeal, they can actually take a further appeal to the Supreme Court. Now, the same rules apply what it did for the Magistrates' Court, so there must be a point of general public importance. So what the law lords will do in the Supreme Court is they'll review the case and make a decision just like the other courts. So it is worth noting that you have got that final appeal court there. They also may refer points to the European Court of Justice if it's under Article 267, where it involves a case of domestic law not effectively applying or sticking to European Union law. But obviously it's very rare for criminal cases for this to happen. It just is worth knowing it on those factors. Now, the next thing we're going to do is we're going to look at how to put this together as an 18-mark question. So we're going to plan an 18-mark question that will go in your handout on your 7A plan. What I expect then is for this to be written up and put into an actual question. So I'll make bullet points on here that you could copy as your plan, and then you can use this for writing it up afterwards as well, okay? So the question states, describe the different ways that the prosecution and defence can challenge a decision of the Crown Court. Now, it is worth noting that it's a Crown Court, so you don't need to refer to the Magistrates' Court in this section, okay? Now then, the first thing that you would need to mention is the types of appeals that you can have. So you can have conviction or sentence appeals that would go to the Court of Appeal. Criminal Division. Oh, 1 eye extra. Okay, so So that would be your first point, that you can have these that go there. Now, you do need to mention that to go to the Court of Appeal Criminal Division, you need to have leave to appeal. So you would have to mention that as an extra bit. Now, that's either a leave to appeal from the Court of Appeal itself or from the Crown Judge, a certificate saying that you've got a good point of law in there to be appealing. Now, the only ground for allowing conviction appeals, so if we're focusing now solely on the conviction appeals, we'll need to know, or you'll need to talk about a conviction being unsafe. So this is for conviction appeals and that a conviction's unsafe. And you need to say what could happen in this one. So for an unsafe conviction, you could order a retrial, quash a conviction in the defendant's appeal, so you can allow the appeal and make sure that they're acquitted and found not guilty. Now, one point to mention here, though, is the fact in relation to this, new evidence is a good reason for a conviction being unsafe. So you want to link it in there. So new evidence is a good reason for a conviction to be unsafe. You would talk about perhaps DNA evidence coming to light, evidence that wasn't presented at trial, or new witnesses. They could also count as new evidence. Therefore, it means it's in the interest of the justice to get an appeal for that reason. Now, if it is an appeal against sentence, you need to say what your sentence appeal are along with your conviction appeal. So your conviction appeal, you do need to mention the powers of the court. So the powers of the court would need to be mentioned. So that is the fact that they can confirm, vary, quash, that we discussed on the previous slides, and the different ones. So they could obviously vary a sentence or they could vary a conviction. So you do need to go over those and mention each of the powers, one for sentence appeals, one for conviction appeals. Once you've done that, the next thing that is needed in here is the Criminal Case Review Commission. So you would have to say about the Criminal Case Review Commission. So that they can refer cases to the Court of Appeal when all other appeal avenues have been exhausted, if they think it is a miscarriage of justice. Now, that is the main bit that you need for your for your defence appeal. So obviously you need to look at defence. Now, if we split this off, once you've talked about the defences, so this above here is relation to the defence, you then need to talk about the prosecution. So we'll put the prosecution plan at the bottom. So the first thing that you need to talk about in terms of the prosecution is where you're asking for the Attorney General to get leave to appeal for lenient sentences. Oh. That's spelled a little bit wrong, isn't it? Okay, so you need to obviously look at the fact that you can appeal for lenient sentences. And you also need to say that they can appeal as well for a point of law. So the fact that they can appeal on a point of law. Not car, we'll say law there. So they can do it for a point of law as well. You would need to say that they can appeal for a jury acquittal. So that is where you've had jury nobbling. You may want to mention there as well that for your jury acquittal, when you've got jury nobbling, that they could, or the rules of double jeopardy, that they can try in the same set of facts if they've got new evidence in there as well. You would need to mention that under the Criminal Justice Act, so you've got your double jeopardy, so we'll write that on there, so you've got that as well. So you've got your double jeopardy to include on there. You also need to include any rulings or any appeals on the ruling from a judge, so where a judge has made a point of law and then the case has ended due to that, so you need to add that in there. Then your final element that you would need to add as well is the final appeal that you have to the Supreme Court. So both prosecution and defence can appeal to the Supreme Court. So that would be your final one that you would need to mention on there. But you must need a point of general public importance, and it is worth noting that very few cases actually do get appealed to the Supreme Court, because not many have that significant point of public importance. Now, to get your level 4 answer, you need to make sure that you have said all of the prosecution and defence. So you would need to mention all of this area here. You need to mention each and every single one of these under the defence. Then you do need to mention prosecution as well. So each and every single one of these points would need to be mentioned for a level 4. Now, you need to have both details for conviction and sentence appeal from both courts. So you would need to mention the conviction appeals and then the powers of the courts to the sentence appeals as well. So do make sure you've got both of those in there for your level 4 answer. Now, the second type of question that we can get on here is an apply question. So you can see we've got an apply question right in front of us. We're asked to define how or explain how George can challenge the decision of a court. Now, you've got to work your way through and talk about each of the powers depending on what type of appeal we've got going on there. So what we need to know at first is that obviously it is in Crown Court, so you've got a Crown Court appeal. He was sentenced to 12 years imprisonment. He wants to appeal because there has been a new witness, and they don't think the law on manslaughter was interpreted correctly. And he also wants to appeal against his sentence as he feels that it is too harsh. Okay, so the first point that we have got, we need to note that the conviction and sentence appeal would go to the Court of Appeal. So you need to say it would go to the Criminal Division of the Court of Appeal. Identify that there's no actual leave to appeal here. So he would have to get the Court of Appeal to say that it's okay to appeal, or he would have to get a note from the, certificate from the trial judge saying that it's worth getting an appeal. Now, the reason here, you might want to say that the fact that there is a potential new witness or incorrect interpretation of the law, that could give a reason for a leave to appeal. Having said that, you then need to mention that for conviction appeals, they need to show that the conviction is therefore unsafe. So you need to say that it is unsafe. Now, grounds that could cover unsafe here is the fact that it's been a new witness. So you're applying there would be the fact that new witnesses have come forward on there. You would also be able to bring up at this point the misinterpretation of the law. Now, this misinterpretation could give you rights as there, so it could be another reason as to why that conviction is unsafe. So I would link it into the unsafe conviction, so the misinterpretation there. Sentence, you do need to give me some details about the sentence appeal. So once you've talked about that, you want to look at the sentence appeal then. So sentence appeal there. You need to say the powers that they've got for the sentence appeal, so worth noting that his sentence could be reduced or kept the same. And then your final point that you would need to put in there is your final point, final route of appeal. So that would take you to the Supreme Court, and that would be the last thing, so you would be able to go there. Now, again, say it's very highly unlikely, as Supreme Court hear in very minority of cases, because you do need leave to appeal, and do say you need a general point of a point of general public importance. Now, you could argue the misinterpretation of the law of manslaughter. You might need to get that clarified by the Supreme Court, so it could be a good reason. So you need to bring that into there as well, okay? Now, we can see from the mark schemes, so if we look down at the mark schemes down here, we have got each and every one of those points that needs to be identified and how it does need to be applied. So please make sure you do have a read through of these and see what you need to do. Now, things to remember, as per usual, are the fact that you do need to refer to George as D or he or something, otherwise you can't get out of the level 2, and then your points of what you need to cover are down here. So these are what we've gone through and how you would talk about those to get in the answers there. So your mark scheme of what answer comes there, so you get 2 marks for each one for a point, so you get 1 mark for a point. So if you've explained the appeal to the Court of Appeal, saying for a conviction and sentence, that would be fine, and then you get a 2nd point if you apply it. So you do need to refer it specifically to the scenario as well. Once you've done that and you've wrote out your answer, so once you've put together your plan in your handout, I would like you to write this out. So point in normal pen and applied point, and then in your handout you'll find there's some scenarios for the for Crown Court appeals. Again, you can have a practice of these so that you're ready and prepared for anything that comes up in that exam. Okay, thank you.